What is a Waqf property? Waqf refers to the movable or immovable properties dedicated exclusively for religious or charitable purposes under the Islamic law. A Waqf property is non-transferable and held perpetually in the name of God. It can either be for public charitable purposes or held private to benefit an individual's descendants. The proceeds from a Waqf typically fund educational institutions, graveyards, mosques, and shelter homes, benefiting a large number of Muslims. What is a Waqf board? A Waqf board is a legal entity with nominated members to manage Waqf properties under the Waqf Act 1995. The board appoints a custodian to each property to ensure its proceeds are used for intended purposes. Waqf boards currently control 8.7 lakh properties spanning 9.4 lakh acres across India with an estimated value of 1.2 lakh crores. It makes them the third largest landowner in India after the armed forces and the Indian Railways. Central Waqf Council, CWC, established in 1964, oversees and advises state-level Waqf boards across India. What is the 1995 Waqf Act? The Waqf Act of 1995 regulates Awqaf, assets dedicated and notified as Waqf by a Waqif, the person who dedicates property for purposes recognized by Muslim law as pious, religious, or charitable. Under the 1995 Act, in case of dispute whether a property can be considered a Waqf, the decision of the Waqf tribunal in respect of such matter shall be final. The 1995 Act was amended in 2013 to give far-reaching powers to the Waqf board to designate a property as Waqf property. This has since been contentious. What are the proposed amendments in Waqf Amendment Bill 2024? The bill aims to restrict the power of Waqf boards to manage its properties and provides for more government regulation. The bill proposes to make registration with the district collector's office mandatory for any Waqf property so that the property can be evaluated. It also states that any government property identified or declared as Waqf property before or after the commencement of this act shall not be deemed to be a Waqf property. The district collector will be the arbiter to decide whether a property is Waqf property or government land, and the decision shall be final. Once decided, the collector can make necessary changes to the revenue record and submit a report to the state government. The bill also states that such property shall not be treated as Waqf property till the collector submits his report to the state government. In case of dispute with the decision of the Waqf board, appeals can now be made in the respective high courts, HCs. A Waqf property can be considered suspect or disputed in the absence of a valid documentation, waqfnama, and it can no longer be used till the final decision is made by the district collector. Currently, a property can be considered as a Waqf, even if its original declaration is suspect or disputed. It empowers the central government to direct the audit of any Waqf at any time by an auditor appointed by the Comptroller and Auditor General of India or by any officer designated by the central government for that purpose. It also aims to ensure the representation of Muslim women and non-Muslims in the Central Waqf Council and the state Waqf boards by including 2 women and 2 non-Muslims among their members. Criticism of the Waqf Amendment Bill 2024. According to the All India Muslim Personal Law Board, AVMPLB, the bill seeks to alter the nature of Waqf properties and makes it easier for the government or any individual to usurp them. For example, empowering the collector as the arbiter and not the Waqf tribunal gives the government a significant say in regulation of Waqf properties. Opposition parties allege that the proposals aim to deprive the Muslim community from their freedom to manage religious affairs, guaranteed under Article 26 of the Indian Constitution. However, the central government argued that the demand to regulate Waqf boards comes from the Muslim community itself.